Hi everyone, my name is Teresa Lubano. Today I'm going to talk to you about IP and creative work protection in business. This is my personal perspective, considering I do have two lines of business. So before I begin, I'd like to just sort of show best practice by crediting the creator of this image of a lady statuette. The name of the creator is Pavel Danilyuk. I downloaded the image from Pixels, right? Now, pexels.com is a fantastic royalty free image bank for images and videos that can be freely downloaded for use. And the beauty of this is that, you don't also necessarily have to attribute the designer or the photographer of their works. But of course, it is appreciated. So, this quick 7-minute presentation is actually in two parts. Sorry, it's in 6 parts. So I'll quickly whisk through them. I'll talk about the basics of the IP. I'll talk about how I trademarked my brand and got an award. I'll also take you through just sort of how someone can protect their IP using automatic copyrights, which is something that is privileged to all creators. And then share with you some clauses out of what you can include in your contracts in regards to IP. And then share with you a cheat sheet, and of course finish with an infringement of IP example. So I guess I think we've heard it clearly here. Intellectual property refers to products or creations of the human mind. Normally they're intangibles, but they could also be tangible. But intrinsically, they are fruits of the human creative innovation. Now, of human creativity and innovation. There's also a WIPO definition, and I think this is my favorite. It says, they say the creation of a new idea, whether tangible and intangible, that can be innovative or inventive. And these would include many, many things, such as literary works, inventions, designs, brands, and symbols, names, and images used in commerce. Now, in terms of types of intellectual property, in Kenya, we have at least 4 different types. So the industrial properties like patents and trademarks and trade secrets. And then there's also copyright. There's also sui generis. This is really, it means one of a kind or unique protection for traditional knowledge and folklore. And there's also utility models. I won't go into the definitions because I think this is something that you can read online. Now, to begin, I'd like to share with you a trademark that I registered. But before I do this, I'd like to just define what a trademark is, because I think it's a single most important thing for any creative to have for their brand. So a trademark is a sign capable of being represented graphically, and trademarks are capable of distinguishing goods or services of one undertaking from those of another. And what the highlight phrase there is just a distinguished mark or sign. So for us, the Nanjala company, we have registered the logo that you see on the left and all its iterations. I personally have registered it as a trademark under Kenyan law. I drew it by hand, enhanced it digitally. Its main features are is a stylized font that is handwritten. Now, what you see is a distinctive cursive handwriting. And if you notice, the letter J has a comma at the top of it rather than the conventional dot. Notice also that I've consistently, I think the brand, when you see it in communication, you'll see it in a distinct mint green. It quite never changes. And of course, when we do a copy, you'll always see it in black, right? So what I've trademarked is not just the mark, but also the color associated, which is a pattern 337C, right? So this is all protected. Now, another thing I'd like to mention is not only did I trademark the mark, I actually trademarked a 3D version of it. So I registered both 2D and 3D, and the logo is protected. And that simply means that even when it appears in 3D, it's also protected. And what I did is I lodged a registration with KIPI in various classifications. I think there were 2 to 4. And what happened was KIPI, which is Kenya Industrial Property Institute, what they do is they publish the mark on their journal, and it was done in May 2022. And then a few months later, I actually got my certificate. So those are the 2 certificates you see there. And in Kenyan law, a trademark expires after 10 years. So the idea is you would renew it after the 10-year validity period, and you continue enjoying the benefits of your trademark. Now, they are not as affordable as copyrights. Copyrights, I think, to lodge a copyright on any intellectual property works would be essentially around 1,000 bob. Whereas for trademarks, you would be spending around 30 to 40,000 Kenya shillings, right? And this would primarily include things like legal fees, government registration fees, and clerical works, and of course for your lawyer. But what is great is that so no matter what area of sub brand I go into, so long as I'm using the mark, it's protected, and I can continue using it in my works, right? Now until 2033. So I think that's something to note. And I'd advise everyone who has a brand to at least trademark their brand. Right. So just to close on that, in 2018, I was very lucky to have received a recognition award alongside a couple of women. And I remember they were dedicating a certificate of recognition to women who are promoting innovation and creativity within Kenya. And I vividly remember myself with other business women, including notable figures like Esther Passaris of Adopt the Light, as well as Catherine Masitsa of, Samantha Bridal, getting this award. And it was a fantastic day, pomp and flair and whatnot. And I think what was significant about this award was that we were recognized, and I specifically was recognized for having lodged a trademark with them, which was really considered groundbreaking in the sense that not many people go and lodge a 2D and a 3D trademark. So I like this quote about copyrights, and it says, "Copyrights exist the moment work is created." So notice that I didn't say copyrights exist the moment one has an idea. So if you have an idea in your mind, it's really not, it cannot be copyrighted. Copyrights cover published and unpublished works. So definitely it needs to manifest in something, something in a document, as a code, and so on and so forth. And so therefore, when you're looking to copyright your works, think of things like, literary works, drama, musical, artistic works, poetry, novels, music, song, visual arts, and so on. Though copyrights are automatic, it is important that creators take the necessary steps to register for copyrights, particularly if you're looking to commercialize your works. And I'll show you some examples. So these are some of the works that I'd consider perhaps, registering. And what you can do to protect the work is to actually put a watermark. Now, and always make sure that you have the original file and save it properly, preferably in a file. You can also decide to incorporate your logo. Like if you look at these 3 instances, one, it's embedded in the image. The second one is word mark is written on the post. And of course, there's an identity there that has been created. So the idea here is that if your logo is already in the creative, then someone will definitely know it's yours. In a sense, you're actually protecting your work. In this instance, it's just by you using the little copyright symbol, which is a C in a circle. So if you look at the post here, and if you read there, it says, copyright C, the artist exclusively processes the copyrights of the design, and the animation of the video clip is actually Undameta. So again, these are just instances where I've actually been able to protect my work. Now, definitely also ensure you exert creative authority. Exert your creative authority and IP rights by having detailed drawings saved, descriptions, plans, records recorded, so that in future, in case someone infringes your copyrights, you're able to prove that the work indeed is yours because you're holding the originals. So here are just some of the instances where I do protect my work, right? So these are just illustrations that I have, and I'll save them. I even have the sketches. I have the final digital file. And of course, in websites where I upload my work, I always make sure that, my name is there, right? So I'll close with contracts, because I think when you look at the creative world, particularly when you're being commissioned to do work, you must know how to prepare contracts. So here are three different versions of what you need to include. So the first one is definitely have a confidentiality and copyrights clause. This is to acknowledge that the information provided by an Angela company in this technical proposal presentation is unique to this business and confidential. Therefore, anyone reading this document agrees to disclose any of the agrees not to disclose any of the information on this document without written permission from the Nanjala company. It is also acknowledged by the reader of this document that the information furnished in this presentation, other than information that is in the public domain, will be kept in the strictest confidence. All rights reserved. No artworks may be used without explicit permission and authorization from the agency. So again, that's just one. And if you're passing exclusive and if the proposed copyright clause are for you to showcase that you own exclusive copyrights, then this is the nature of the clause. It would say something like, the consultant owns all the intellectual property rights in the product and company branding as between so and so. So that's the client and the consultant. All work products developed in whole or in part by the consultant in the present and future belongs to the consultant. These include, but are not limited to, inventions, literary works, artistic works, designs, symbols, names, and images used in commercial works. So again, so you may decide to say this and then say, whatever I'm working on, I am actually passing the rights to you. But anything outside what I haven't shared with you and that you've paid for remains strictly mine. And this is really important for clients where you see them saying, show me one sample, show me sample, two sample, three sample, four. Only send them when they see the 3-4 samples. They should only have copyrights to the one that they approve and use. All the others are still your property, and if they need that work, you need to charge them for it. If that is the case, or if they want to sort of continue working with you, right? And then finally, this one is a bit detailed, and this is a copyrights clause example for specific creative deliverables. So, for example, you have a list of things that you need to provide. So usually you'll add a schedule to the end of your contract, and what you'll do is you'll write such a narrative. I'd love you to just screenshot this page for purposes of time for you to read, right? Then, so so basically, a cheat sheet, always secure written contracts. I think this is really important. All business transactions should start with a contract and be signed, and everyone should have a copy. Maintain your copies, keep them safe. And this is something I do in my business, every single contract, right? Enforce an NDA, because also copyright clauses are hidden in the NDAs. Look at them critically. If you feel like you need to negotiate on it, just please be open to doing it, because sometimes you could get a contract that upstages the NDA, or vice versa. So you almost want to see that there's consistency across and that you're also protected. Demand for signed quotes or a local purchase order. Insist on signed documents, as well as get receipts, ETR receipts if possible. And then, of course, all these documents, you should safeguard them by filing them and sending copies to yourself if they're digital ones, so that you always remember. And then, of course, every time you do a presentation, make sure you put that C, because then, you know that if someone ever intends to use it commercially, they should know that it's your work and they should ask for permission, right? And then, of course, never, ever, ever use other people's works. Just make sure you seek permission or review the intellectual property license terms so that you're clear on usage. Finally, and to end, sorry, I've taken a bit more of my time, but I'd like to mention that, my copyrights have been infringed upon several times, particularly in Twitter and Facebook. Social media is a place where people actually do infringe copyrights. But I think what's important is, five key things that I'd advise here is one, you need to assess the degree of IP infringement, record it, like take a screenshot because people tend to pull this down and claim that they didn't do it. And then when you're certain that it is an infringement, look for the evidence. Again, take pictures or, check through all the social media so that you have screenshots of everything. So if they put a post using Hootsuite and they have the infringement on Twitter, Instagram, LinkedIn, you can screenshot all the platforms, right? Before you actually make your move, right? And then this is what will serve as evidence. Um, and I think you've seen, I've also just mentioned that these are things that you need to have. And then, of course, get a good lawyer who will help you to present your case to the person who's infringing. And then formally notify them in writing, some paper trail, because that's important. Just stating that you feel that this party has infringed on your copyrights, right? And then follow the next steps on the advice of the lawyer. So once they confirm or agree or disagree, yours is just to share the communication with the lawyer, and he'll advise you on the next steps and so on. Hardly do people go to court in this market, but I think, it's always good to actually know the steps. And should you go to court, claim what's yours, right? So I think that's it. Thank you very much. I'm happy to hear any questions. Thank you.